use the terminology to make it clear what we're talking about. So the double app is when you're doing one for entry and one for qualified for the April 1st start dates to be able to get better results in the lottery. That's a double app, and entry level and qualified, that's all you can do is 2 because of the 2 skill levels, and there's a different wage range. When we have clients that are doing double apps, we normally knock $200 off. We're doing because we do the whole process for both of them. We do all the way through to the I-129 for both of them, and the steps have to be done for both apps. However, if you're just doing one app and you're considering adding a second app to divide the number of workers so you have better odds in the lottery, what we would normally charge $3,600 for now, because we're charging $3,800 for the initial app. Now we're doing that for $3,000 if somebody adds, and we are literally almost full. We've got a handful of slots. Normally at this point, I'll ask my legal assistants, can you take 1 or 2 more? But at some point we cut it off. But we do have room a little bit still for adding these on. And then for duplicate apps, whether it's for entry level or for qualified, we're doing those for $2,500. And that's because on a duplicate app, we are not going to do the I-129 on one of those. And so it is less work for us. We still have to do the prevailing wage request. We still have to do the ETA 9142 application and all of the steps there. But we're going to end up dropping one before we get to the final labor certification. So just if you are interested in doing some of these, I would like to say one more thing about this before we do questions and comments. You know, we have plenty of business every year. We are not so much trying to increase the number of apps or anything like that as we are to get good results for our clients. This strategy, and you're going to hear at the end of this session right before lunch, Jackie Katzenell with Landscapes USA is going to share the results they got on this, and you will get good results. The reason is because you're going to get workers. You're going to have a 75% chance of getting your workers, or what people tell me, I want my workers. You're going to have a 75% chance of getting them up here, at least most of them, by doing the double apps. But by having these duplicate apps as insurance apps, if both of these get in those later groups, let's say in 25% of the people that did it, 75% got one of them in group A through C, but 75% got one of them in A through C. 25% did not and got both of them in the later groups, which means they're only going to be able to bring up Northern Triangle workers anyway. So if you're in groups E, F, or G, you're not going to get workers from Mexico, right? Or any other. You're going to only be able to get Northern Triangle. And the chances are, even if you're doing double apps, the chances are 25% that both of those apps are going to be in those later groups of D through G. And so what I tell my clients, and I have a lot of clients that have been doing this for years, and they've been with us for years, and they'll say, no, I don't want to do that. I don't want Northern Triangle people. I want my guys. And I say, I get it. And we're going to give best efforts to get you your guys. But what happens if both of your apps get in, E, F, or G? Both of them get in there. Do you want to get no guys? I mean, or bring them up in June? Or do you want to get guys in March? So if this one gets in group G, do you want to just write that app off in those number of workers? Or do you want to bring up some guys that can be trained? I was talking to a client during the break, and I said, how long to train a guy? We were talking about this very issue. How long does it take to train a guy? And they're saying 3 weeks. Well, so you're in business. Even if both of these got in the later groups, you got one in group F and one in group G, you're not going to be bringing those workers up until late May or June from Northern Triangle. Why not bring them up from Northern Triangle in March? And know you're going to have guys that might not be your guys that you're wanting, but they're going to be able to work and be trained and go to work when you need them, and you can be fully staffed, not just getting one app or whatever. And so what I highly recommend is start developing an alternative labor source. Not that we want you to use that alternative labor source, we just want you to have that alternative labor source, in case, rather than having no workers. And to me, that doesn't make sense of saying, if I don't get my guys and I don't want anything, and then lose that business when you could actually be growing your business and tell your guys, hey guys, I did everything I could. And we can do transfers, we can do different things to get you some of your key workers, even if you got both of those double apps in later groups. So I'm just, I do encourage it. I like to see my clients get workers and grow their businesses and do well, and the H2B program work well for them. I'll say this last thing about it, and then we'll take questions. I compare it to a game of chance, and I'm not a gambler, but my dad used to like to play blackjack, and he wasn't a gambler either. He, maybe when they were on a cruise ship or something, he might wager $50 or $100. In fact, he and I used to go out of Port Aransas just to hang out, and we go on one of those gambling boats or whatever out of there, and we do $50, and he liked to play blackjack. And he read books on how to play blackjack and everything. I don't do that, but he read books on it, and he's pretty good. And what I learned from my dad with him doing that is, if you know how to play the game, you can win a lot of the time if you know what you're doing. If you don't know what you're doing, they're just going to take your money, right? They're professionals at taking your money, But if you know what you're doing, you can win a lot of the time. Same thing with H2B. That lottery is a game of chance. So this is how people that are using the program successfully, this is how they're playing the game. This is how they know they're going to get labor, And so, yeah, it costs a little bit more money, but what's the greater cost? Not getting labor and not having labor next year, or paying a little bit extra, for these additional apps, even though we're going to throw 2 of them away, but you're going to get your guys. So it's something I truly believe in, and we're going to share, Jackie's going to be sharing the results they got. Questions or comments? There are a few hands that went up. Jackie.
I have 2 comments just based on what you were talking about earlier.
Sure.
First, we had in the last year both a DHS and a DOL audit. Thankfully came through both of them without any citations, violations, came through fine. One of the first things that they looked for in both cases was that poster. So that is an easy thing to forget. Don't forget it. Stick it up where your labor law posters are. That is one of the first things that they went to look for. So make sure you're doing that. And then secondly, when it comes to the prohibited fees agreement that we get with our processors and all of that, we bring a group from Guatemala, and I have a travel agent that's in Guatemala. I didn't have her sign that agreement because she wasn't really part of the visa process, right? She was just helping me book flights. But that was one thing the auditor mentioned to me. He didn't cite us for it, but he said, any third party that you use really needs to sign that agreement. And so if you're using, even if they have nothing to do, she doesn't recruit for us, nothing, she just books my flights. But now moving forward, we'll always get her to sign an agreement as well. So any third party that you're using should sign a prohibited fees agreement. So I just wanted to kind of mention that.
Yeah. Another thing that's interesting to know, these investigators and auditors are required to find a violation. When they're sent out, they require them, say, find a violation. And the reason they do that is because they reported back to Congress, the DOL reported back to Congress and said something like 88% of H2B employers were in violation. Well, there are little things like, they caught her not putting a poster up or something like that. And so they go back for more money to the federal government and say 88% of these employers are in violation of the terms of the program. But they're minor violations. Some of them are major, but most of them are minor. And they're getting more money. If you've ever worked for a federal agency, they always want more for their budget. And so they're getting more money from the federal government to do these audits and investigations. Yes?
Being said, though, we weren't cited for anything, so it is possible.
Yeah.
If you cooperate with the DOL officer, with the DHS officer, they're trying to get the bad apples.
Yeah.
Do everything. You're really trying your best to do everything that you're supposed supposed to do and you're cooperative with them, we didn't get any violations at all.
That's fantastic. That's our goal. That's what we want to see. Amen.
Yeah,
Yes.
we provide a vehicle to our H2B guys that are licensed on days off.
Right.
They pay for the gas.
Mm-hmm.
Is that a problem? It's not on
It
the
could
job
be.
order.
You could
It's
get
not on the
cited.
job order.
So that could be viewed as a benefit that you're offering to relocating workers. So if in doubt, list it on the job order. That way, you know, it's there and you don't get dinged for it.
What do we do going forward? Do I stop it or do I keep it up?
For what?
Do I continue this the rest of the year till they're gone, or do I stop it?
Well, whatever it's going to be, how long do you offer it for?
Well, November 30th is when they leave.
So you offer it to the foreign workers for the whole time they're here. They can use the company vehicle. So I would put under benefits, company vehicle available for use for relocating workers only. Employee pays the gas. And that way you're covered.
I understand, but my question is, it's happening right now. Do I stop it, or do we just... Trying to help
Okay,
these guys
so
out.
here's the thing on asking me a question, and in front of 75 people. I've got to tell you to do what's illegal, right? Or because I'm giving you legal advice. So I would say yes, because it's not on the job order. I hate to say that, but. So y'all that know me, you know you're always going to get a conservative answer from me. I don't want you getting in trouble. I'm going to tell you the safe route, you know. I have a low tolerance for pain and problems and things like that, you know. So I don't want you to have any pains or problems or anything either. And I don't want you to come back and say, well, Robert, that's not what you told me, and here and now I'm getting dinged for it. You know, I'm having to pay for it. So, you know, there's liability there too. So I'm always going to give you the safe route. And you'll appreciate that if you ever go through one of these investigations, you know, that I gave you good, solid advice. So I would say, listen, next year I'm going to put it on the job order. Just went to a seminar. He told me I can't do that, you know, but we can make sure you get to the store once a week or whatever. And sometimes, if you're doing that, it's probably not a bad thing, because a lot of times I had somebody that was letting them use a company vehicle and found out they were traveling all over the place on the weekends in it. Okay, good. All right. Anybody else? Sure.
Jackie answered my question, but I'll ask it for the benefit of other people who...
Okay.
Yeah, because, you know, I wanted to know, you said in terms of the range that you have to include in there the prevailing wage versus the range that you're paying your U.S. workers. During the year, if you want to increase the pay of your U.S. worker, you have somebody that's really good, they ask for more money, you want to increase that.
Mm-hmm.
You want to... How to do that without violating what you've already did in your range.
Right. So let me explain the wage range just briefly here and give you an idea how you want to do it. So if you're doing the double apps, let's say on the entry level, let's just for argument's sake, your prevailing wage is $17 an hour. Okay? And then you go for an entry level worker. You know, if they have some experience, maybe 2 months, or they seem like a good worker, you know, you might be willing to offer them a little bit more. Maybe you're paying them up to $18 an hour starting off. You know, if somebody says, hey, this other company, ABC Landscaping, is offering me $18, you might offer them $18 too to start them at, just to have them, because you're needing to up your labor force. And then for experienced workers, maybe you're paying 18, you know, to 20. And so what we do on something like this is what I'll ask you is, what do you want to be paying these foreign workers? And you might say, well, usually we're paying them, their experience and everything, usually we're paying them about 18 to 20. You know, so that's good for these qualified workers, you know, that are coming up that you want to bring up. You would do it something like this: 17 to 18, and then 18 through 20. The overlap there is going to be, excuse me, I'm wrong. rather than do it 18, you'd want to up it to 20 here. You don't have to pay that extra $2, and you'd want to have this one go up to 22. So 17 to 20 for entry level, 18 to 22 for qualified. The overlap there is 18 to 20, right? Because 20's the high end on the lower paid. And so everybody's going to be able to get 18 to 20, which is where you said you wanted to be on the foreign workers coming up. So that overlap is 18 to 20, and that's where we want to be. And so what I'm going to ask you when we talk about wage ranges is what are you paying, and then what do you want to be paying these foreign workers, and we're going to make sure that that overlap has you covered whichever application they come up on. And your guys, your qualified guys, can come up, even though they have experience, they can be overqualified. You could bring up somebody with a PhD in horticulture on an entry-level application. If he's willing to take that wage and do that work, not do the skilled work he could do, he's just doing labor. If he's willing to take that job, you can bring up somebody that's highly qualified on that entry-level app. Workers can always be overqualified. But we want to make sure, and so, you say, well, we're not paying anybody over $20. Well, you might say over 15 years experience, you can make between 20 and 22. You're probably not getting too many people with 15 years experience coming and, applying for jobs and everything, but that just gives us the range that we need to build into those wage ranges. Keep in mind that whatever in a wage range that you offer a U.S. worker has to be offered to the foreign worker. Not the same wage, but the same wage criteria or the same wage structure. So if a 10-year experienced worker gets $20 an hour if he's a U.S. worker, then the foreign worker that has 10 years experience should also get that same wage. So basically treating them the same. Yeah, Jackie.
I just want to point out, though, that if we have people that have been here more than a year, more than 52 weeks, we can pay them higher than the wage range. They fall outside of that criteria, correct?
If they
incumbent workers.
Yes, that's a good point. So, and we're going to get into that in a minute. And let me mention this. A lot of times I'm touching on things that we go over here in more detail in the afternoon. And one of those things is corresponding and incumbent workers. There is an exception to the corresponding worker requirement. So U.S. workers have to be treated the same unless they've been working for you for 52 weeks or more. Those are U.S. workers that have been working with you for 52 weeks or more. That's a little more simplified than it is, but roughly 52 weeks if they've been here a year working for you, they're called an incumbent worker, and they can be paid outside that wage range. They're not subject to the same criteria that the U.S. workers, the foreign workers are. Or the corresponding workers, they're not under the same rules. I would still include their wage in the higher end wage range because it's still a landscaping position. So let's say they're getting 25 hours. Now, if they're a superintendent, they're not a landscape laborer. That's not considered the same position. But DOL has grouped all landscape laborers together as landscape laborers, that mean wage. We're building in the skill level, right? And so since we're building it in, if they're a crew leader, anything under a superintendent, I would add their pay to this higher end qualified wage of 3 months or more, that if they go up to $25, I'd carry that up to $25 and just say, you have to be here like 10 years like he has to be able to be making that, or you have to be here for 10 years and be a crew leader and know how to, and have your irrigation license or something like that. Whatever he has, they'd have to have the same things, But I think it'd be safe if they're looking at your wages to make sure that everybody that's a landscape laborer falls within one of those pay ranges. Okay? Anybody else? Yes?
Excuse me. Do we have to include state mandated paid time off as part of the job order? So in Michigan, we're required for anyone who worked more than 25 hours and worked for a week in the prior year, we now have to pay, looks like up to 72 hours of paid time off.
Yeah. So if it's required by the state government, then it's required for all employees, right?
Yes.
Yeah, so you have to do it. And part of the requirements for H2B employers is to be in compliance with all federal, state, and local employment or labor laws. And so there's nothing wrong with that.
Okay.
So do you have to put it as a benefit? Is that what you're asking?
Yes.
I would, to be safe.
Okay.
You know, just say, you know, try to keep it as brief as possible. Paid time off after X number of hours, you know, or 72 hours after, you know,
Yes.
X number of time on the job.
So the corollary to that is that we occasionally hire high school students, so they're minors, they're not allowed to operate power equipment or drive vehicles.
Right,
So they don't really fall into this job order.
right.
Can we continue to hire them for less than prevailing wage without creating an issue?
You could certainly make the argument that it's a different job position and that they don't do these same duties. It is landscape labor, right?
Right.
And so so what I'll tell you is you could certainly make that argument and I think you'd be okay, but DOL could take the opposite position on that and say, we think they're landscape laborers.
Okay.
You see what I'm saying?
Yes.
So DOL is always, they're the Department of Labor. And what a lot of people don't know is most of the top people in the Department of Labor are ex-union people. So the labor organizations have infiltrated the Department of Labor and actually run the Department of Labor. The unions have a tremendous influence on the Department of Labor. That being the case, they're always going to take the side of labor, not the employer. They're, you know, you would expect that of unions, but now they're so the inmates are running the asylum.
Well said.
Okay. Yes.
So right now we offer our crews time off for vacation and holiday pay and stuff like that. Do we need to offer that after 90 days to our H2B?
Well, what is the criteria to get the benefit?
Work 90 days,
Work 90 days and you get?
at least holiday pay.
So paid holidays off?
Yeah, like 4th of July, Labor Day, Memorial Day.
So the way you can do that is you can put a stipulation to a benefit. You can say to get this benefit, you have to have worked here X number of months. So a lot of times, even insurance is that way a lot of times. You can have insurance that says you don't qualify for health insurance until you've been here for X number of months, usually 3 months. You can say you don't qualify for this benefit till you've been here a year or 6 months. But whatever it is for the U.S. worker, it has to apply to the foreign worker. Now, another way you can get around it to where you don't have your feet to the fire on this is you could say, for instance, like holiday bonus or certain different types of bonus, whatever it might be. We'll say like a Christmas bonus or profit sharing. I normally recommend say Christmas bonuses may be available but are not guaranteed. Put it in there, but say it's not guaranteed. And then it's kind of at your discretion, you know, as far as paying it. But if you pay it for some, you got to pay it for others based on the same criteria. But so we can make it kind of iffy, but still put it in there and give you the ability to do it or not. And so, so yes, you have to put it in there, but you can put wording in there that makes it contingent upon being there for a certain number of months or even on your own discretion. Does that make sense?
Yes.
So, you know, there's ways around having your feet held to the fire, you know, as far as having to do something. You can make it a little bit more vague, but you still want to put it in there because it is a benefit. Okay? Anybody else? Okay, we're going to go ahead and move on. And we'll pick up some more questions at the end after lunch. Jackie's going to come on here in about an hour and share with y'all her experience. So we're on me see where we're at. Okay, the audit file. Oh, what some people had asked, they had more questions about the 3/4 guarantee, the audit file, and stuff like that. And what I wanted to let y'all know is we get into all of that in more detail. So if I haven't answered all your questions, we'll probably get them answered as we go into the part in the handbook about that particular issue. So we're at major changes. We're on page 14, and I want to make sure where we need to get through here. We had some changes in fees, and I want to get to those. Okay. That shows me where I need to get through. So we're about where we need to be. Major changes in the 2015 H2B regulations. The last time there was a major overhaul in the regulations, though they're doing piecemeal overhauls, the last major change was in 2015. They changed the definition of peak load. It used to be 10 months. It's now 9 months. Most people don't need their workers more than 9 months anyway, but if you go over 9 months, they'll challenge you on whether you qualify. Staggering of workers is disallowed. People used to bring their workers up. They would need some in March, but then they'd need most of them in April and May, and then less during the summer maybe. And they used to stagger their workers. That's not allowed. You're supposed to bring up all your workers just as soon as you can. You can still do staggering, but you have to do it by a second application. So let's say, this is not true in Texas, but let's say in a northern state, their busiest months are summer and fall. They don't need them real early because they have a late start, and so they could bring them up. They could bring them some up in March or April 1st, let's say, for April and May, and then they could bring a second group up during the summer months to say maybe June through September. And so those year-round workers are the less number that they need on the early spring and the late fall, but where their growing season, where the grass is growing up north, is June through late September. That's when they need like twice as many of their temporary workers. So they could do another app just for their biggest growing season. You can stagger that way, but you can't just wait to bring up half your workers just for those summer months in September. You'd have to do a second app. And then so no staggering of workers. The bifurcated application process when it begins with the registration, that is in the regulations. They haven't started it yet. I'm on page 16. Deductions now must be disclosed in the job order, any deductions other than those required by law. So deduction for Social Security and Medicare, you don't have to list that other than to say all deductions required by law are made, but and you don't have to say deductions for child support if court ordered. Those are all required by law. You don't have to list those. But if you do deductions for uniforms, you do deductions for broken windows, which are problematic, but whatever deductions you do, you have to list on the job order. So if you do deductions for housing, that has to be on there. And they have to be listed on the job order or they are not allowed. You cannot charge them for costs for the benefit of the employer, and uniforms are now considered benefit of the employer, though there's a way to do it, and I'll go ahead and mention it here because we don't have a section on it. If you make them buy uniforms, the way to kind of get around it is to issue every employee when they come in one set of uniforms. So they get a shirt, they get trousers and a cap or whatever, and that's free, and you have to give that free because you're requiring them to wear it. And you say you get one company issued uniform, and you're going to have to wash that every day after work, and dry it out overnight and wear it back the next day. Or if you want more, it's optional. You can buy additional sets of uniforms for X number of dollars. You're not requiring those additional sets of uniforms. but it's highly likely they're going to want a few sets. You know, you can get away with that. So you're requiring them to wear a uniform, you're giving them one set, and then offering optionally for them to get more than one. Most employers are just paying for it. And it used to be you could charge them for uniforms. That's problematic now. Earning statements. You do have to give them a full earning statement. It's got to have total earnings, hourly rate of pay, hours offered. I have that underlined because most people aren't doing that. And hours worked. Jackie had brought up something, and I've heard this as well. Most of your ADP or QuickBooks, they do have a place there to put notes. You know, if you want to put some notes, and you can put the hours offered there. Two things. She mentioned they go right for the poster because they know most employers aren't putting the poster up. That's why we give it to you. You just tear it out and put it up. But they also go after the hours offered on the pay stubs because most people aren't doing it because it's very difficult to track and put on the pay stub. But you can put it in the notes section, and you can track it if you do time sheets. The crew leader is doing a timesheet, you can track it on those. But you have to put hours offered on the pay stub, hours worked. Everybody's usually doing total earnings, hourly rate, hours worked, any itemization of deductions, beginning and end dates of the pay period, and the employer's name, address, and FEIN number. All of those are required to be on the pay stub. The employer must provide all necessary tools, supplies, and equipment. May not charge the worker for damage, loss, or normal wear and tear. So that's been kind of common of charging workers. There's intentional or negligent stuff you can charge them for, but things that are common to the job, the employer would bear those costs. Posting of the job order has to be there for 15 consecutive days during recruitment in 2 conspicuous locations. That was a part of the 2015 regulations as well. The job order must be disclosed to the foreign worker and U.S. workers prior to starting the job, or if they're already on the job. If they only speak Spanish, you've got to get it to them in Spanish. A lot of people think that's a problem, but if you haven't done this yet, all of us use computers. We either use Google or we use Microsoft. Both those have document translate deals. So you can take our job order and you can copy that and paste that into a Word document and then go up to translate and translate the whole thing. And they do a pretty good job of translating. It's not perfect, but it's pretty good. So you want to translate that into Spanish for them. Disclosure of the job order, display of workers' rights poster, contact of previous employees is required during recruitment. As we mentioned, recruitment of workers required until 21 days prior to the date of need. Contract with agents and recruiters, all of this we've gone over. Non-discriminatory hiring practices, and they came up with the corresponding employment requirement that any U.S. workers get the same treatment as the foreign workers unless they're incumbent workers. You look down there at 15B, it says exempt if employed for over 52 weeks with at least 35 hours of work each week and in at least the 48 of the 52 work weeks prior to the start date of the application. So if they have been there more than 52 weeks, they're going to be incumbent workers. They are exempt from the corresponding worker requirement. Wage surveys, we used to do a lot of wage surveys to try to get the wages down. They're not allowed anymore. It really has to be a state-done survey, and there are not many of those. So the employer can't do it on their own anymore. Section 5 is on running the race to win. We used to file, there was still a filing window, but they were processed in the order received. There wasn't a lottery. And so we would stay up till midnight on the night before the filing window opened, and we would start filing all our applications at 12:01 Eastern Time, and I'd have coffee and pizza for my legal assistants because, you know, they were processed in the order received. And now it doesn't matter whether they go in first or not. They're all going into a randomized lottery. If you're new to the program, you have just as much chance of getting in Group A as somebody who's been doing it for 30 years. You know, and I've looked at the numbers. I get them every year. I get a copy of every company and what group their applications were in. And like I said, I'll look at Brightview, and they'll have the same percentage in Group A or Group G as all the other ones have. It's just they're doing more applications. And so, so now it's a randomized lottery, and it doesn't matter as far as getting in first. You just got to get in that 3-day window. But what does matter is the recruitment, because you still have to run the race during recruitment, because every day that you take over 15 days, there's thousands of applications going in ahead of you every day. And so if you take 16 days instead of 15, you know, a couple of thousand applications went in ahead of you. You know, if you take another day, several thousand went in ahead of you. And that can really make the difference between getting capped out or not, getting your guys or not getting your guys, you know, getting in that Group A through C or not. And, or excuse me, getting in the 33,000 with Groups A through C. So anyway, you want to get in Group A. That's the strategy for getting in those groups that will get you your guys. But you want to do everything possible, same-day turnaround. Do the whole process as quickly as possible, and we will too. Read our communications and our emails completely and respond as necessary, because sometimes if it wasn't done right, then we have to go back to you and do it over or change some things. Try to get everything done as quickly as possible. Prepare documents in advance for all applications, your payroll summaries, sales summaries. The reason I'm saying that, if we don't have them and you get an NOD and they're saying prove seasonality and prove that the numbers of workers are legitimate, then we've got to go to you. You've got to create those documents, you know, when we could have just immediately turned it around. And if we can do it same day on an NOD, we'll probably get the NOA that same day. But if we take 2 or 3 days, that analyst takes your application off their desk, and you know, they're working on ones that they can work on, and so they might not get back to it as quick. We found that if we turn it around immediately, they get back on it immediately. And so if we have the documents all prepared, we can do that. And so prepare documents in advance. Review all your paperwork for mistakes. Mistakes can cause delays. File on the very first day possible. Stay ahead of the pack. Do recruitment each day as applicants come in. So a lot of times people during that 15 days of recruitment, they're doing the applications, they're doing the interviews, but they're not keeping those records straight. They're not doing their recruitment report as they're doing the interviews, and they're saving all that till the end on day 15. But then it takes them 2 days, things come up, people are busy, it takes them 2 days to do the recruitment report. If you're doing the recruitment report as you're doing the interviews and seeing the applicants and responding to the applicants, then on day 15 you're ready to go. You just put some final touches on it and get it to us, and we can file it same day. Follow the 2-letter, 2-interview process according to our instructions. This is all in our information letter, but what we recommend is a 2-letter, 2-interview application process, and this is what it boils down to. And we have these sample letters in our email that goes out when you get the notice of acceptance, and that starts the recruitment period. And so what the 2 letters are is, the first letter says, we got your application or your resume or your information from the state workforce agency that said you're interested in coming to work for us, you know, at ABC Landscaping. Please contact us within 4 business days to set up an interview. DOL says you have to give them at least 4 days. They could be out of town, they could be busy. You have to give them at least 4 business days to respond. So now you're putting the ball in their court. So this name's been given to you. You're putting the ball in the applicant's court, and you're saying, you get back with us and set up an interview within 4 business days. 90% of your applicants will not get back and set up an interview, probably more than that. So you wait the 4 business days, they don't contact you, you send them a second letter saying, on such and such a date, we sent you a letter asking you to set up an interview within 4 business days if you're interested in coming to work for our company. Since we have not heard from you, we assume you are no longer interested or have found employment elsewhere. Thank you for your interest. Sincerely, you send them that email and you're done with that applicant. You've made a good faith effort to hire them. You sent them a letter offering them an interview. They didn't follow up on it. You told them, you even gave them a second chance, really, by sending that second letter. You're saying, hey, we're writing you off. Sometimes you'll get one that says, oh, I was out of town, I'd like to come in. Usually they won't come in. But now you've done everything you got to do with those 2 letters, and you've got documentation. You've got those emails. So if you ever got audited, hey, we made a good faith effort to hire all those U.S. workers. Not all of them. You're probably going to get 2 or 3 at the most. But you made a good faith effort. And all of that's been done. You don't have to wait on the back end to get back with them. You do them as you're going through the process, the 15 days. Now, if you have an applicant come in, which rarely happens, but you have an applicant come in and they say, yes, I'd like to do an interview. 90% of the time they won't show up for the interview. But if they do show up for the interview, you go ahead and tell them about the job. You tell them, and you can do this on the phone too. You tell them it's a seasonal job. It's only April 1st through whatever, December 1st. You tell them it's, working outside. You don't want to downsell it too obviously, but tell them there's no benefits if there's no benefits. Tell them the pay is just, whatever it is, $17 an hour. And then when you've given them a understanding that it's a seasonal job, there's not any benefits or anything, you want to ask them, if it's on the phone or in person, does this sound like something you'd be interested in? And just be quiet and let them respond. 90% of the time they're going to say, no, I need more money, or they're going to say, no, I can't work on Fridays, or, let me think about it. If they say, let me think about it, what you want to say is, so for right now, you're not accepting the position. Is that correct? And you want to get a decision from them, because once you have that decision, you can send them a confirmation letter saying, we interviewed you on whatever the date was. This is to confirm that you did not accept the position. Thank you for coming in. If you change your mind or whatever, let us know, and you're done with them. Very rarely you're going to have one that you tell them all the requirements of the job and what it pays and everything. Very rarely you're going to have one that says, gee whiz, yeah, I'd like the job, and or like this guy I met that said, I've always wanted to be, to do landscape labor. And so the guy says, yeah, I want the job. And so then what we recommend you do is one of 2 things. Number one is have another person they need to see while you check out their references. So maybe the owner or something like that. And say, okay, we're going to check out your references, and then we're going to have you come back in and interview with the owner, and check out their references. And so you're going to do a second interview, because there's a 90% chance, not exactly, but roughly like 90%, they won't come in for the second interview. And then you can end it there as well. But another thing you can do, the second thing you can do is if you really need some workers. Let's say you're interviewing in January, but you're a Texas year-round landscape company and you're short-staffed. You can say, look, that job we offered you doesn't start till April 1st, but we've got some openings for permanent workers, year-round workers right now. We're a little short-staffed. Would you like to come in Monday and start? You can't make them take the year-round position. They might say, oh, no, I'm taking care of my mother. She's ill, and she's supposed to get ready. I'm supposed to be through taking care of her in March, and April 1st start date is perfect. I want to start then. But normally they'll say, yeah, I'll start Monday. Most of the time they would take the Monday start over the April 1st start. If they do that, I don't know if it's exactly 90, but most of the time they will not show up. So when they don't show up, you can write them a letter and say, we interviewed you, you were supposed to start on Monday. Because you didn't show up, we assume you're no longer interested or you have found employment elsewhere. All of that is detailed in the notice of acceptance letter that we give you. All the templates are there. You're not going to have many applicants, but we guide you through the process exactly what to do on each one. We're not trying not to hire U.S. workers. We're trying to show a good faith effort to hire U.S. workers, but we also don't want you being stuck with a bunch of people that don't show up for the job, that say, yeah, I'll take the job, and don't show up. So we've found these processes to be successful in just getting you workers that really want the job. And by the way, if you hire that person for a Monday start date, and he comes in on Monday, but he leaves on Tuesday, you still send them a letter, this to confirm you came in on Monday, but you didn't come in again on Tuesday because you're not coming in, you didn't come back in for the job. We assume you're no longer interested or found employment elsewhere, and you won't lose the visa. If you offer the person that permanent position and they take it and they stay on the job, you won't lose a visa. If you hire a U.S. worker if you hire a U.S. worker and they stay on the job, you will lose a visa. So say you were wanting 21 workers and you got one U.S. hire, which I don't think we had any U.S. hires this last year, but very few if we did. But if you had one U.S. hire out of 21, they're going to dock you a visa and approve you for 20 instead of 21. So you do have to hire qualified U.S. workers that want the job, but you can go through these steps and you can weed out a lot of people that really aren't interested in working for you and find out if they're serious. So two interview and 2 letter and 2 interview process. You want to finish the recruitment as soon as possible. It can be done in 15 days. You want to document and confirm everything done to try to hire each applicant. Don't be too conclusory on your description of what was done to try to hire each applicant. Tell each step that you went through. You tried to call them on the phone. You had to leave a voicemail. So you sent them a letter offering them an interview. They never responded. You tried to call them again, but still didn't get an answer or had to leave another voicemail. And so after 4 days they didn't respond. You sent them the final letter saying since you hadn't heard from them, you assume they're no longer interested. Put all those things on there because it shows a good faith effort. Everything you did, put on there. But do at least 2 letters. Do 1 letter offering them an interview within 4 business days to contact you, and another one confirming that they didn't, if they didn't, or what happened. That they called and said they weren't interested. You spoke to them on the phone. They turned down the job. Whatever happened, be thorough. And what you want to do on that recruitment report is you want it to be clear what the final resolution of that applicant's application was. They turned down the job, they were hired, they never showed up for an interview, whatever it was, why they weren't hired, and what the steps you did to try to hire them or have an interview. So you want to do everything you can to get that done within the 15 days. When everything was done in the order received, I had a few employers here in Austin that couldn't reach somebody. They found out they had a referral from the state workforce agency on the last day when they could submit the recruitment report, and the cap was close to being hit. And I've had a couple employers that I said, well, go out to their house and see if they're there, And I've had employers go out to I haven't done this for a long time, but would go out to their house and interview them right there at their house. Hey, I saw you were interested in a job. It's not because they were so interested in hiring them. They just didn't want to get capped out, and they wanted to make sure they got it done. They didn't want to take 4 days and send them a letter and give them 4 days to wait because the cap would be hit in that time. So, I've done that a few times. I wouldn't do that. You're not going to get many applicants in this job market. And so just follow the 2-letter, 2 interview process whenever possible. Call your legal assistant regularly during the process. Make sure if we contact you for anything that you stay in touch with us. Don't leave the office or go on vacation during that time. We need to get it done thoroughly and as quickly as possible. type the recruitment report as you go along. Send in the recruitment report to the legal assistant maybe 4 days prior to the 15th day so we can review it and make any corrections. Have a final draft ready right prior to the 15th day. Submit it to the legal assistant on or right before the 15th day. Dated on the very first day possible, which will be the 15th day. Don't miss the recruitment deadline. Don't go on vacation. Be available for any response from DOL until the labor certification. And then there's something else I was thinking of as I was going through that laundry list, maybe to come back to me. You want to, the State Workforce Agency. This can come back and bite you. I couldn't believe it, but I had a client that's been doing this for years. This year that he got audited, and the auditor, or the investigator, it was an investigation, came up with applicants at the State Workforce Agency that weren't on their final recruitment report. And so he didn't even check with the State Workforce Agency. You're required to check with the State Workforce Agency. There's a, like in Texas, it's Work in Texas. So the Texas Workforce Commission has their website for jobs, and you have a job posting there. And it'll tell you on that job posting whether you've had any applicants. Well, this employer who's been doing the program for years apparently was never checking with the State Workforce Agency to see if he'd had any applicants. You're required to do that to make sure if the State Workforce Agency has sent you applicants that you're following up on them. So you don't want to have an investigator show you the applicants that you didn't follow up on because they're not on your recruitment report that they have. And so make sure that each day you're checking with that website. It's real easy to do. You just go on your website, you got the password and everything, see if you've had any applicants. It doesn't take 2 minutes. And if you have, send them out that letter number 1, that tells them to contact you within 4 business days. And if they don't, then you can move on. So anyway, that was it. Most people aren't willing to do all these things. They're going to take their time. They're going to be days later than you will. And you'll not only do it thoroughly, but you will do it as quickly as it can be done and keep yourself at the front of the line. There are only 66,000 visas that are authorized by Congress. We get about double that amount through this supplemental visas. But as most of y'all know, October 1st, there's 33,000 of them. There's April 1st, there's 33,000. You can keep track of where the cap is at by going to the USCIS website and looking at that. It'll give you the cap count. It's updated every few days as we're in the running the race. And there's Exhibit 13 is an example of that cap count. The caps are usually being hit earlier each year. So the audit file, things that should be in the audit file, if you look down on page 20 to see, you should have all supporting documents in there. So even if we don't submit your supporting documents that prove the number of workers and dates of need, those payroll summaries, sales summaries should be in your audit file. They'll want to see those documents. They are still required, even though we do not have to submit them oftentimes with your application. You're required to have proof that you qualify for the program. And so if you get audited, a lot of times they'll ask for those supporting documents. The prevailing wage determination that needs to be in there. The job order that I showed you earlier needs to be in there. Proof of posting that job order. So when you put up the job order in 2 conspicuous places during the recruitment period, maybe you put one by the time clock, maybe you put one in the eating area. Take a picture with your phone of it going up there, and in each place. And send that to us with your recruitment report. So we say we put it up in 2 conspicuous places, and we can say, photos are attached. That's just further proof that you did put it up as you were supposed to. You're not required to do the photo, but it helps in everything to have proof. So put that up there. The recruitment results letter, you also want to make sure that is not, even though you date it on the 15th day, remember it's still required that you continue to do the recruitment up until 21 days prior to the start date, So you would want to have a second recruitment results letter dated on that date, March 11th. If it's an April 1st start date, you'd want to have a March 11th recruitment results letter, and maybe you have 2 more applicants come in there. But they'll want to see both of those, not just the one that you sent in. They'll want to see the one that has the March 11th start date. Sometimes on supplemental visas, if you sent your petition in more than 30 days after the start date, they'll want supplemental recruitment. They'll want another letter on the date that supplemental recruitment was supposed to end. We had in those, this is kind of funny, we had in those Department of Labor debarments of these employers for what was done by this other law firm that did not do the work they were supposed to do, and then got audited. When they got audited, they tried to fool the Department of Labor, trying to show that they did do the recruitment that they didn't do, and they just changed the date on the March or February recruitment letter to June or whatever, and they submitted that in the audit as a recruitment results letter for the supplemental recruitment that was done for the supplemental visas. And so one of my clients, the law firm had never even contacted them. They didn't even know that they had a supplemental petition in. They didn't sign it. They never saw it. They were never contacted. And they testified in court. It was on Zoom, but they testified saying, he never contacted us. We have no emails from him. You know, we didn't even know there was a petition in there. We didn't know there was a problem until we got the letter of debarment. And we didn't even know that, anything was even going on or that he had done anything. And the DOL attorney said, well, how do you explain this? And she shows the recruitment results letter with the June date and everything. And they're saying, is that your signature on there? And actually it was her manager's. And she says, yeah, that's his signature, but we never signed that. And I'm sitting there looking at it, and the date on the top of the letter was June, but in the body of the letter saying, that we posted this, on such and such a date. That was the March date. They didn't change the date in the letter. And I said, Your Honor, this is a bogus recruitment results letter. And it was just silence. And I said, look at that date in there. And so it showed she was telling the truth. And the lawyer, believe it or not, was altering documents and submitting them with the employer's signature on there that the employer had never seen or signed. It was the March letter with the date at the top changed. So anyway, said all that to say you do have to have, anytime there's a recruitment, you do have to have the letter for those dates of the recruitment. Job order with this SWA. What you want to do, you're checking that State Workforce Agency. SWA stands for State Workforce Agency. So when you're checking the website to see if you had any applicants, print that out. Print that job order out and just put it in your audit file. And because it shows it was up there and everything, you can print that out and then print it out on the last day. When you check it on the last day to show that there were no applicants, just print it out. It's real easy to do. Hit print. And have that in there. Proof of union contact if you have a collective bargaining agreement, but most of you don't. You're not party to a collective bargaining agreement with a union. You want the statement of temporary need in there, the ETA 9142 application, any wage surveys, which we don't do anymore, or they don't do them anymore. DOL labor certification, copy of the I-129 petition, and copy of the consular processing records. You want to keep receipts for any payment for visas, transportation to and from the place of employment. So even when you give them money, don't give them cash to pay for any expenses. If you're giving something to a worker, get them to sign a receipt on it so you can show, or give them a check for it, so that you've got proof of payment. Contracts with agents and recruiters, just make a copy of that, put it in the audit file. Letters from workers stating no prohibited fees were paid. I suggest during orientation, when the workers come up, that you have a letter saying in Spanish, this is to confirm that I have not paid anybody any fee as a condition of employment with ABC Landscaping or whatever your company's name is. Have a letter that the worker signs when they get here saying, I've paid no prohibited fee. And that way, even if it turns out later that it happened, you can say, well, that's not what they told me, you know, and I don't think it will happen, but you want the worker to tell you it didn't happen. Also, you want to make sure that they have a copy of the job order. Payroll records. You want to put their payroll records in there. That's not that important because you have digital copies of that, but sometimes they're asked for. Records documenting compliance with all program requirements, copies of reports to DHS and DOL of any terminated, absconded, or other non-reporting workers. So if a worker absconds or quits or you fire them, send that letter to DOL within 48 hours and just print off a copy of it. It's an email, just hit print and put that in the audit file. Many of these documents will be produced as the employer goes through the process each year. Any documents you have or see or produce, generate yourself, make sure you put a copy in the audit file. Prevailing wage and wage issues, let me see where we are. Okay, we're good. The prevailing wages, by the way, went up more in this year than I've seen them go up for quite some time. There's a reason they went up so much, and one thing that DOL is fairly accurate on is what wages are actually going, what workers are being paid out there. They keep very thorough records on that. They are the Department of Labor. But right now we have two problems that are really working against these prevailing wages, you know, and causing them to rise. The one thing is inflation. 1 year, over the last 4 years, the inflation rate was 9%. I think right now, what is it, 3% or something like that? But what you got to realize, if you had 9% 1 year and you had 3% another year, that's 9% plus 3%. So over that 4-year period, prices have gone up just in those 2 years, 12%, right? And so it sounds low when you hear 3%, but they didn't go down from when they went up 9%. And so everything's going up. And I really recommend, as employers, you got to start building this in to your prices that you're charging people. You know, because I know employers, you're competing with people out there that are hiring illegal labor. And that, I don't suggest you do that, but that's hard to compete when they're paying $10 an hour and everything. But you need to be able to justify, hey, all of our workers go through background checks. All of our workers are legal laborers. So if you're doing work for an apartment complex, they've got liability out there. If you got a bunch of illegal workers, not you, but your competition, they got a bunch of illegal workers out there, they could be criminals, they could be breaking into apartments, they could be predators, you know, they don't know who those illegal workers are. You could say, and bring that up, say people that are hiring illegal workers, yeah, they'll give you a lower rate on the work, but all our workers are legal, you know, background check, stuff like that. Justify your higher rate, because there's people out there right now, there are undocumented workers that have companies of all undocumented workers. They're not paying any taxes, you know. They're bringing people up there that are totally illegal and will work for $10 an hour. And but when you're doing things legally, which you should be doing, you're having to go up based on inflation, but you're also having to go up based on the cost of labor. So labor is going up even more than inflation is, because when you can't get labor and you got to go down to the day labor corner and they're bidding up, you know, I've had employers tell me, you'd think these guys have a college degree in what we do, because they want $20 an hour and they want us to pay for lunch and they want transportation to and from. They got all these demands, and you might not meet those demands, but somebody out there who's going to lose a contract, if he doesn't mow those yards, he's going to pay $20 an hour. Well, that's getting calculated into the prevailing wage, because we're in a labor crisis. The cost of labor is going up, and that's forcing your prevailing wage up, right? And so you need to consider that in building that cost, and then justifying it that we're using all legal labor. You know, these guys are not a safety hazard and everything to your residents here in the apartment complex. But two things are driving them up. The cost of labor is going up significantly because we're in a labor crisis, and also inflation. So things you can do to keep your prevailing wages low. You can try to basically just offer 40 hours a week. And if you can avoid overtime, it's going to reduce the cost of labor tremendously, especially if you're used to paying, 10 to 20 hours a week in overtime. That's a huge additional cost of labor that if you're an H2B employer, you don't have to be paying that kind of overtime. You can limit it. You can go to 4-day, 10-hour a day, 10 hours a day, 4-day weeks, so you can you can also do the shifts, as I mentioned, the 4-day, 10-hour shifts. Usually, another thing as far as the prevailing wage and all that's concerned, another thing that's been going up as DOL goes up on these wages, they almost never go back down again. And what it's doing, and you have to consider this, is when you have to pay $17 an hour and your competitor is used to paying $14 an hour, $15 an hour, that's a problem in a sense, but it's also a problem for him, not just you. Because if you're paying $17 an hour, and his workers find out from your workers that they're getting paid $17 an hour, his workers are going to be coming to you, wanting to go to work for you, or they're going to tell him, hey, these other H2B employers are paying $17 an hour, you got to pay me $17 an hour, or I'm going to go work for one of them. And so labor is at a premium right now, and the higher wages are not just, DOL is not just making us pay the higher wages, they're making them pay the higher wages too, because the labor, we're going to go where they're getting paid more. And so it does make your competitive situation as far as labor better. Okay, we're at the Appendix B. I'm going to try to go through this quickly. Before I do, and then I'm going to have Jackie come up here and share a little bit about her experience this last year. Look on page 26, where it talks about penalties. And I knew of an employer that told me, they came to me from another law firm, and that other law firm was telling them to lie on their applications and do winter applications, which you can do winter applications, but they were telling them to lie on those so that they could send their workers home. They didn't even have to work, or say they were doing Christmas lighting when they weren't doing Christmas lighting. And I found out this was going on, and I sent out a letter, an email to all my clients saying, do not let anybody talk you into lying on one of these applications. Tell the truth. And I will encourage you to tell the truth, because there are significant fines and penalties associated with submitting false applications. And the immigration fraud is a felony. I've never heard of anybody being prosecuted for a felony, but I told them in this email, I said, look, I don't make a habit of committing felonies, and I don't think you should either. So don't let anybody talk you into lying and saying you're doing stuff that you're not doing, for pragmatic reasons and everything. Because if they find out in an investigation, those things are out there. So it says on the form that you sign on the Appendix B, it says, I declare under penalty of perjury that I've read and reviewed this application, and that to the best of my knowledge the information contained therein is true and accurate. I understand that to knowingly furnish false information in the preparation of this form or any supplement thereunto, or to aid, abet, or counsel another to do so is a felony, punishable by a $250 fine or 5 years in the federal penitentiary, or both. And so that's over the signature block. Now, just for your information, I've proven to DOL, like in that hearing where those people were debarred, where not only the employers weren't doing that, but previous lawyer was doing that, and no one was prosecuted in that. They were debarred, but there was no criminal penalties, is what I'm saying. And that was as egregious as anything I've seen ever, because they were being counseled to put false information, and then just basically take the visas, and then they didn't have to do the work that they were being told to do, and they didn't even, they could even go home during the winter months, and that way they'd be able to avoid the cap, because the workers had already been counted against the cap. And so it's rarely, what I'm saying is, I've never heard of anybody prosecuted for criminal sanctions. However, they are doing civil money penalties, and they do have the authority to do that. So you don't want to be ever giving false information, knowingly on your Appendix B. Also, I mentioned earlier that if there is an audit or investigation, they go down this Appendix B just like a laundry list. They go right down and see if you did everything that you said you would do. So, first of all, the job opportunity is a bona fide, full-time temporary position of at least 35 hours a week. So, when those people were being counseled, oh, you don't even have to work them, they can go back to Mexico and then just come up, and they've already been counted toward the cap. That was violating this on the Appendix B. It wasn't a full-time position. It wasn't a bona fide, job opportunity. It was just being used to try to beat the cap. There's no strike or lockout at any of the employer's work sites within the area of intended employment. The job opportunity was and is open to any qualified U.S. worker regardless of race, color, national origin, age, sex, religion, disability, or citizenship. So no discrimination. The employer has not or will not offer terms, wages, or working conditions to U.S. workers that are less favorable to those offered or will be offered to H2B workers, or impose restrictions or obligations on U.S. workers that are not imposed on H2B workers. So basically, you got to treat the workers the same. Number 5, the offered wage equals or exceeds the highest or most recent prevailing wage that is or will be issued by the department. So you got to pay at least the prevailing wage. Number 6, the offered wage is not based on commissions, bonuses, or other incentives unless the employer guarantees a wage earned. I did have an employer that went through an investigation, and he wasn't paying the prevailing wage. He wasn't even paying by the hour. He was paying commissions based on how many yards they mowed. And these guys were making way more than the prevailing wage. These guys were making like the equivalent of $30 an hour because they were doing these yards so quickly and everything. And I was shocked. The investigation went on for a couple of years, and they didn't cite him for any of that because the workers were so happy and they were making so much money that they cited him, but they didn't fine him or anything. They said what you're doing is not allowed, but you're paying a lot more than the prevailing wage. Don't do that. You can do it, but how you have to do it is you have to say, we pay 10%. On yards mowed, but at all times we pay at least $17 an hour, with time and a half for overtime. So that way you can pay the commissions, but you have to also keep track of the hours. So if the commissions fell below the hourly rate, that you at least pay the hourly rate. Does that make sense? So you can get away with stuff like that, but you have to disclose it in the job order, and you can do it, but you still always have to pay at least the prevailing wage. The offered wage is not based on commissions. 7, during the period of employment that is subject of this application, the employer will comply with all applicable federal, state, and local employment, health, and safety laws. And so that's the one that we were talking about earlier. If the states, some of these states now are putting employment laws in place. Colorado does. I believe Pennsylvania does. What was the state you mentioned? Michigan. Yeah, so some states are starting to do that, and you have to comply with those as well. Employers not laid off any similarly employed U.S. workers 120 days before or after, unless the layoff is for lawful job-related reasons. The employer and its agents and attorneys and employees have not sought or received payment of any kind from the worker for any activity related to obtaining certification or employment. Number 10, upon the separation from employment of any H2B or corresponding worker employed under this application, if such separation occurs prior to the end date of the employment specified in this application, the employer will notify the Department of Labor in writing of the separation and not later than 2 work days after such separation. They give you up to 5 days if the worker absconded to determine whether they've absconded or not. And so maybe a worker doesn't show up, but he's sick. He's laid out with pneumonia, and you don't know that. So you got 5 days to determine if he's just sick or, didn't come in for another reason, or if he's absconded. We don't get that many absconding workers, but it does happen. You have 5 days to determine if they've absconded, and then from the 5th day you have 48 hours, 2 days to report them. If it's a fire or quit, then you just have the 48 hours. And so all you do is fill in their name and visa number. We have a form that we use, or the content is in the back of this book, and you just fill in the worker's information, the date that they quit or were fired or absconded, and you email that to USCIS and DOL and CC USCIS. And we've got their information in the back where to send it to. It's not difficult. Number 11, the employer will not place any H2B workers employed pursuant to this application outside the area of intended employment or in a job classification not listed on the approved application. So you can't take landscape workers and use them for carpentry or construction. The employer has demonstrated that it has a temporary need as defined by 20 CFR 655.6. Number 13, the employer will make all deductions from workers' paychecks required by law and only those additional authorized and reasonable deductions disclosed in the job order. Number 14, the employer has specified in the job order any applicable minimum productivity standards which the worker must meet in order to retain the job. So if there is something minimum they have to do, it has to be in the job order. So if, has to be able to work in Texas weather or something like that. We don't really have that much problem with these minimum standards. On H2A, we see that more. So many bushels of something being harvested, per day minimum. Number 15, the employer guarantees to offer the workers employment for a total number of work hours equal to at least 3/4 of the work days in each 12-week period, or a 6-week period if the certified period of employment is less than 120 days. So the 3/4 guarantee, and we've got an exhibit in the back that goes into that in more detail as well. If before the expiration of the date specified in the job order, the services of a worker are no longer required for reasons beyond the control of the employer due to fire, weather, or other act of God, unforeseeable man-made catastrophic event, the employer may terminate the job order with written approval of the certifying officer. So if something happens and it's just no way that if you were in one of those hurricanes in Houston and it wiped out your yard and your business and everything, and you're not able to continue employment and you want to cancel the job order, you tell us and we let the certifying officer know and get it canceled. The employer will keep a record of workers' earnings and provide the workers with the required earnings statement on or before each payday, which must be at least every 2 weeks or according to the prevailing practice in the area. 18, the employer has disclosed how it will provide transportation and subsistence costs in the job order. So the employer not only has to pay, this is another thing, and in audits and investigations, a lot of employers aren't doing this. So not only do you have to pay the bus fare or the plane fare of the workers here and back if they stay for the full time, but you have to offer subsistence. And that's, I believe it's $15.88 a day minimum for meals, so while they're at the consulate and while they're coming up, they have to be reimbursed the minimum of $15.88. Most of the workers don't know, but they can get up to, I think it's $59, is that correct? $59 a day with receipts. So they could be eating at a steakhouse instead of a burger place, but most of them don't know that. So you ask, do you have any receipts for meals? No, and then you give them the $15.88. But if they know that and they keep the receipts, they can be getting more. I don't know about steakhouse. You can't get too many steaks for that. But anyway, they could be eating better with $59 a day if they have receipts. What number was I on?
That's 18.
I don't know why I'm not finding that. What? 18? Employers are close. How? Okay. The employer will provide to workers without charge or deposit, number 19, all tools, supplies, and equipment required to perform the duties assigned. The employer will provide a copy of the job order to all H2B workers no later than when the worker applies for a visa, if located abroad, no later than the time of the job offer if the H2B worker is changing employment from one H2B employer to a subsequent H2B employer, and to workers in corresponding employment no later than on the day the work commences. So really, when the workers come up, you want to provide everybody, the foreign worker and the U.S. workers, a copy of the job order. The employer has, and we give it to their processor. We send a copy of the job order to the processor, and they give a copy of that to the worker, or they're required to give one to the worker prior to going into the consulate. The employer has posted a department-provided poster detailing H2B corresponding workers' rights and protections in a conspicuous location at the place of employment, number 21. The employer has, and we got that in the back of the book, just post it. The employer has not and will not, has not or will not cause another person to intimidate, threaten, or restrain, coerce, blacklist, or discharge, or in any manner discriminate against any person with respect to this application, basically. The employer has and will contractually forbid in writing any agent or recruiter or any employee of such agents or recruiters whom the employer engages directly or indirectly in international recruitment of H2B workers to seek or receive payments or other compensation from prospective workers. And as Jackie pointed out, you want to make sure that anybody that's involved, even travel agents, are signing an agreement along those lines that they won't charge the workers. The employer will conduct all required recruitment activities pursuant to 20 CFR 65540. That's basically the recruitment process, and we guide you through that. The employer has and will continue to cooperate with the state workforce agency by accepting referrals and will hire all qualified and eligible U.S. workers who apply for the job opportunity until 21 days before the date of need. And many employers aren't doing that. That's why, and most employers never read this Appendix B. I've been surprised, how few actually read it. And the reason I'm reading it now, or at least going over it, is to make you aware of these things, because in these audits and investigations, they're usually going number by number down these obligations on the Appendix B. So you have to continue to recruit up to 21 days prior to the date of need. You're not getting any applicants during the 15 days, and you're probably not getting any applicants up until 21 days prior. You just have to know that if you do get applicants, you need to keep a record of those and document them as well. You're not required to take applicants after the workers have arrived. The employer will cooperate with any agent of the Secretary of Labor who is exercising or attempting to exercise the department's authority, including investigations and audits. And so you need to cooperate, but you can also hire your attorney to represent you in it, to where it's a buffer between them, and I can be answering questions without you having to deal with them. And the employer will retain all documents pertaining to this application and registration, the recruitment-related documents, the payroll records, and related documents for 3 years as required by the regulations. So when you read through those, you might want to review them again. They're really not that difficult. It sounds like a lot. There's 27 requirements. Most of y'all are doing all of those anyway. There's probably a few in there that you're not doing. And they're not that burdensome, like the reporting requirement. That's another one that a lot of times people aren't doing the way they should. They're not sending that off within 48 hours. They don't have it because they didn't do it. Usually they'll get dinged on that. They'll get cited. They probably won't get fined, but they could. But it's an easy thing to do. If you know you're supposed to do it, somebody absconded or they quit, you just fill out the person's name, send them an email saying this person's quit. You keep a copy of that and you're good to go. It's an easy thing to do. So most of these things are pretty easy if you just be cognizant to do them. And we're going to do questions after lunch. Is the lunch out there? Y'all? They're ready to go? All right. So we got lunch out there. We are going to ask Jackie to come forward. Before she comes forward, I want to mention, if you have questions about these, let us know. If you are not doing the 4 application and you'd like to do 4 applications, a lot of our clients just do 3. They do one insurance app on the, say, the entry level or something like that. But the surest bet is to have an insurance app on all of your workers. And we're having clients that do that, do it very successfully. And it's a good strategy. And so if you're wanting to do it, we're offering during the seminar some reduced prices. If you are wanting to consider that, grab one of the retainers from your legal assistant. We have some here, and we'll get that paperwork going. Jackie, you ready to come on up? And you want to give her a microphone? And then right after Jackie's through, we'll take an hour off, and we might start up earlier if we're all three. All right, ready?
Hi, I am Jackie Ketzenell. I'm the HR director with Landscapes USA. 2 quick things I wanted to comment on, which wasn't really what I was coming up to talk about, but I wanted to back up what Robert was saying. We just completed our audit that went on for a couple of years, and in our final review, which was 3 hours long with the DOL officer, he literally did go down every single line item in that Appendix B. So that is not an exaggeration. We went through every single one of those in detail. So make sure you know everything that's in there and that you're doing all of that. Also, something that I figured out a couple of, maybe last year, that's just kind of a good tip. You know, we talked about the prevailing wages going up every year. It's really helpful to be able to plan on that. You know, if you have to raise client contracts, I assume most of you are landscapers, maybe not all of you. But whatever, it's helpful to know now for budgetary reasons what your wages are going to be next year. Even if you don't have your prevailing wage determination back yet, you can look up those rates. Sophia helped me with the website that I could go to because they've published the rates. So I've figured out now that in the summer, like anytime I think after July, you can look up those rates so that you have them and you can incorporate those into your budgets for next year, which has been really helpful for us if some of you maybe did not know that. But the main thing I wanted to talk about today was this. We've been doing this for the last couple of years, and we've been really successful. So we have 9, and we are maybe at an advantage maybe over some of you because we have multiple locations, and that does kind of open up more possibilities to us, certainly. But we have 9 visa cities, and 2 years ago, we applied for we had 13 different petitions. I don't think we were doing the duplicate applications yet, but we were doing the double apps. And then this past year we went, I think that year we had 13 petitions for 9 visa cities. This past year we did 15. We did 3 of the early apps, and I think 3 of the double apps in addition to our 9 regular applications. This coming year, we're doing 17. We're adding a couple of the duplicate apps. This past year for our 9 visa cities, doing it that way, following that strategy, which really does work, we got 5 of our cities in Group A, 5 of our petitions in Group A, and 2 in Group B. So we were able to get, out of our 9 visa cities, 7 of them we got into Group A or Group B, which was amazing. And I always say H2B visa, it's a little bit of luck, it's a lot of prayer, and it's a lot of strategy. And this strategy really does work. It just gets your name in the hat more times, really, is what it does. And it increases your odds of getting your workers. So that has really worked for us. I have found that it's well worth the extra money that we've put into the petitions, of course, the extra work that goes into the petitions. Of course, you have extra recruiting periods and all of that kind of stuff, the extra recruitment reports that you have to put together. There is some extra work involved in it, but it is well worth it, and it has really helped us in the end. So I just wanted to encourage everybody to really think about that. The other thing that has helped us, so we do transfer petitions a lot. And if you have multiple locations, you can do transfers. You can even do transfers between yourself and another company that maybe isn't your company. You can do transfers that way as well. But because we have 9 visa cities, if we say this city gets all of their visas and this one doesn't, we can transfer workers from this city to this city. So we can do that. We can kind of spread the wealth between all of our cities and make sure that everybody gets their key employees. So that's really helped us. And that's another advantage of these duplicate apps. So Robert was talking about the duplicate apps being available if you want to get Northern Triangle visas. You can do it. That we have one particular location that we bring our workers from Guatemala anyway, so we always go for the Northern Triangle visa because there's far less risk with that, and that's where those workers come from anyway. But for our other cities, we, like everybody else, we want to bring our returning workers from Mexico. That's our first choice. They're the employees that have all of the experience. That's who we want to be able to use if we can. So the duplicate apps, of course, are a good backup, and you can use those to bring workers from the Northern Triangle countries, which is fantastic. But the other way that helped us this past year, we had one of our locations, Oklahoma was the location, they happened to get, we had double apps for them. They had 2 applications, but they got, I think, groups D and E or F. They were lower down. We were going to be able to transfer. We had enough visas between all of the visas that we got in groups A and B, that we had the visas to be able to transfer their key employees to them. But even when you're going to do that, you still have to be DOL certified. So even though the visas were available maybe at the beginning of April, right, because we had A and B petitions, and we set some aside thinking, okay, we're going to use these as transfer visas. We're going to bring these workers up, but then we're going to transfer them to Oklahoma. We still can't do that until Oklahoma is DOL certified. So if Oklahoma happens to be far down in group E, F, or G, it might be the end of April, beginning of May before they even get DOL certified. So even though you have visas available that you can transfer, you still can't do it, right, until that city is DOL certified. But if Oklahoma was one of these duplicate apps, so because they were a duplicate app, I had a DOL certification dated March for them. So even though we did not use the duplicate app to bring Northern Triangle visas up, because we could do the transfer, which depending on how many locations you have, that's easier for some companies than others. But even though we didn't do it for that purpose, it enabled us to immediately schedule an appointment for them. We didn't have to wait until group E or F or G got DOL certified. We could use that duplicate app. Does that make sense? So that worked out really well for us as well. So we've had a lot of luck. We followed the strategies that these guys, we've been working together since the early 2000s, I think a really long time. We followed he's never steered me wrong. We followed the strategies, and we've just been really lucky with that. So anyway, that's all. I just wanted to share that with all of you, and good luck next season. Sure.
Yeah. That was great. We are going to eat lunch. Let me clarify just a few things real quick that she was talking about. On transfers, so you're transferring workers that are already here or workers that were able to come up on one of your other Group A or something like that. Then you're able to transfer them to another location. You can also do transfers if you're doing winter apps, for instance, of workers who are already in the country, as long as there's an approved labor certification. And so those, even though that application, like Jackie was saying, might have been for the 3/20 start date, which would have been Northern Triangle if you were to bring them up from the consulate, if it's a labor certification, you don't have to use Northern Triangle workers. You can transfer any of those other applicants, say bring them up on a Group A from Mexico, and then transfer them to that 320A application labor cert. Even though they're from Mexico, they're coming to that other location. And so that's one reason what you want to do is be going up on your numbers a little bit each year. You can go up to 20% per year. And if you're doing that, then this double application strategy, let's say on this one you're able to go up one, on each of these you're able to go up one, and each year you're going up a little bit. What has happened over the years to a lot of my clients is sometimes in doing a double app, they've got enough visas on each app to where they'd be okay just on one of the apps. So if they get a Group A and a Group G, a lot of times if they know they're in a Group A, they'll just drop the Group G, and they'll just say, before it gets labor certified, you got to do that before it's labor certified, or you're under the obligations of the labor certification. But if you've got enough workers, a lot of times you can just still play the lottery game and have more than one shot at that earlier group, and then when you get it, look at that and say, is that sufficient? Or you can also, if you're bringing up the 320 apps, see if you just want to bring up those Northern Triangle instead. Then Jackie had mentioned checking out what your prevailing wage is early so that you know how to start bidding your bids and your contracts. That is available July 1st. You might not get your prevailing wage, your from DOL till October or November. But if you'll call your legal assistant and say, I want to know what my prevailing wage is going to be in Dallas, she can tell you, or he can tell you, or I can tell you what your prevailing wage is going to be as of July 1st. We have that online. I've never seen it be wrong. They say you still have to get a determination. You can't just go by that. You still have to have a determination that's specific to your application. But I've never seen it be incorrect, the one that's posted online. So we can find out what that is starting July 1st of each year. One other thing about these 320 apps that I was thinking of as Jackie was sharing is a lot of times people think that it's real expensive to bring Northern Triangle workers because of airfare. They're not coming on a bus, they are coming on a plane. But if you're getting them in March and April, round-trip airfare is like $500 or something like that. I've gone down there several times, and round trip. And then where's Anibal? Is Anibal? Is that right? So if you're in April, March, April, round trip after the Holy Week. So yeah, you don't want to do it during. Yeah, you'd be higher during when people are flying a lot during Holy Week. And then as you get closer to the vacation time that they do vacations down in Central America, is more like getting into late July, August. Those are high times. But if you're getting them in April after Holy Week, May, or before Holy Week in March, you're going to get down around $500. And you're going to be that much on round-trip bus fare, from most places in Mexico. So it's very economical airfare. And also, even though there are new workers that haven't been on the program a lot of times, we are doing recruiting. This is the last thing I'm going to say. We're doing recruiting, most of our recruiting from churches down there. We've got hundreds of churches that we work with. And we're getting vetted through the pastors and everything. It's not a guarantee that they're going to be good workers, but they're at least vetted, and we're getting recommendations from people that know them, so that we're not getting questionable people or people with criminal backgrounds and stuff like that. Usually they do go through vetting, and so we're getting some real good workers from down there. So even though we're encouraging people to at least have that alternative workforce available from Central America, we still try to use everything we can to get them from Mexico if that's where they're wanting them from. But a lot of the things that we're doing are getting real good workers and getting them economically for our clients, that are using those Central American workers. And we'll have our processors after lunch sharing about their services. So we'll go ahead and be dismissed. If y'all would like to go out and grab some lunch. All righty. So we'll just go out these doors to my left, and hope y'all enjoy, and we'll start here back up about 1 o'clock or a little bit earlier.